All right, get ready because today we are taking a deep dive into California's civil lawsuits.
Ooh, sounds exciting.
It is, it is. We've got some serious legal documents here.
Oh, lay it on me.
And specifically, we're looking at attacking the pleadings.
All right, so right off the bat, you can tell we're getting into the nitty-gritty here.
We are, but that's what we're here for, to break it all down.
Absolutely.
This area of law is fascinating because it really shows you the strategies at play even before a case goes to trial.
Yeah, you can almost think of it like a chess match, with legal arguments instead of pawns and rooks.
That's a great way to put it.
You got to think a few steps ahead.
So our mission today is to, kind of demystify all this legal jargon.
Right.
And uncover those strategies lawyers use in those very early stages of a lawsuit.
Yeah, we're going to explore how to attack those pleadings, right? We're talking about things like demurs and motions to strike. And what's interesting is these legal weapons, they aren't as powerful as they used to be.
Really? What happened? Why is that?
Well, the source material points to the introduction of those standardized judicial counsel forms for complaints.
Oh.
So these forms have really simplified that pleading process, right? Which in turn has made it harder to find those little technicalities that lawyers might have used to exploit in the past.
So it's like the state is trying to, make things a little fairer, more straightforward.
Yeah, you could say that. And actually, in limited civil cases, those dealing with smaller claims, the legislature went even further. They restricted these procedures even more.
Oh, interesting.
And, this just makes it clear that they wanted to streamline those smaller cases, like special demurs, which we'll get into later. But those target technical flaws in the pleading, they're completely off the table in limited civil cases.
Wow. So knowing the type of case is crucial right from the start?
Absolutely. And even motions to strike have very limited grounds.
Okay, so we're already getting into the weeds a little bit here.
We are.
But let's start with this demur thing.
Okay, yeah.
What exactly is it? What makes it work?
So a demur, right, it's a challenge to the legal sufficiency of the complaint.
Okay.
But the key here is we assume all the facts stated are actually true.
Right.
So it's not about arguing whether those facts are actually true at this stage, but more like saying, even if everything you claim is true, you still don't have a valid legal claim.
So it's kind of like saying, okay, you told your story, but legally it doesn't add up.
Exactly. That's a great way to put it. And here's where it gets really interesting. A demur can actually be based on things that aren't even mentioned in the complaint itself.
Wait a minute, hold on. You can bring in outside information.
You can. It's called judicial notice.
Okay.
And it's not about just bringing in any random information. No, it's about using facts and legal precedents that are publicly available, undisputed things everyone agrees on.
Okay, so like public records or previous court rulings, that sort of thing.
Exactly, even statutes.
Okay, so it's more like bringing in supporting evidence, but evidence that's already out there.
Exactly. The source material even gives an example. It talks about a case involving what's called a purchase and assumption agreement, or P&A for short.
Okay.
And the demurrer in that case successfully challenged the complaint by relying on judicially noticeable facts.
So you're basically pulling the rug out from under someone with information they might not even have considered.
Sometimes, yeah.
Wow. That's powerful stuff. But are all demurs the same? I mean, are there different types we should know about?
Yes, there are two main types. General and special demurs.
Okay.
So a general demur, that challenges the complaint at its core.
Okay.
Asking, does it even state any valid cause of action at all? And that might not even be the one the plaintiff intended to bring.
So you're saying even if the plaintiff gets the legal theory wrong, if the facts support some kind of claim, they might still be okay.
Exactly. The source material actually mentions a case where that happened. The plaintiff had the wrong legal theory, but the facts actually supported a different valid claim. So the general demur didn't work.
That's a really important distinction.
It is.
So what about these special demurs then?
Those zero in on the more technical flaws within the complaint.
Okay.
Like, is the wording uncertain? Are the parties improperly joined? Did they fail to say if a contract was oral or written? Things like that.
So it's all about dotting your I's and crossing your T's.
Yeah, making sure everything's in order. But remember, we talked about how special demurs aren't allowed in limited civil cases.
Right. Got to know the rules of the game.
Absolutely.
Yeah.
So we've got this demur beast, but when does it make sense to actually use it? When is it worth the time and money?
Yeah, good question.
Well, you have to analyze the advantages and disadvantages.
Yeah. Okay, so let's weigh those pros and cons. What makes a demurrer a good strategic move?
Well, one advantage is you can force the plaintiff to show their hand early on. You might reveal weaknesses in their case right out of the gate.
I like that. Kind of like a legal poker game, getting a peek at the other player's cards.
Exactly.
What else?
Well, sometimes it leads to a quick win.
Right.
The facts just don't support a legal claim, no matter how you spin it.
Okay.
And even if it doesn't outright end the case, it sends a message. It tells the plaintiff, hey, you have a weak case. And that might encourage them to settle.
So it's like a power move, right? Either ends the fight quickly or pushes the other side to the negotiating table.
Exactly. And the source material points out something else, too. Demurrers can be even more effective when the case is assigned to an all-purpose judge.
Wait, why is that? What's so special about an all-purpose judge?
Well, these judges, they handle a wide variety of cases, right? So they might be more inclined to encourage early settlements to manage their really busy dockets.
So it's all about understanding the playing field and the referee.
You got it.
Okay, that makes sense. So we've got the potential benefits, but what about the downsides? When is a demurrer not the right move?
Well, a demurrer can be expensive, time-consuming, and sometimes you might win the battle but lose the war. You risk basically educating the plaintiff on how to fix their complaint.
So you could accidentally give them the roadmap to a stronger case.
Exactly. They could amend their complaint based on your arguments and come back even stronger.
Oh, that's not good.
Yeah. And if the flaw in the pleading is really minor, the judge might just tell the plaintiff to amend it.
Okay.
Leading to even more back and forth.
So it's a calculated risk, right? You got to weigh the reward against the risk of actually helping your opponent.
Exactly. It's a strategic decision.
Okay, that's a thorough look at demurrers.
It is.
But we've got another tool in our arsenal.
Yes, we do.
Something called motions to strike,
Right.
which just the name itself sounds a bit more aggressive, right?
It does have a different feel to it. So a demurrer, that's like a broadside attack on the whole complaint, right? But a motion to strike is more precise.
Okay.
It's about targeting specific parts of the pleading that are problematic.
So less about sinking the whole ship, more about removing the damaged part.
Exactly, like a surgical strike.
I like that analogy. But what kind of material are we talking about here? What's usually targeted?
Well, one common target is what are called conclusory allegations,
Okay.
which are basically claims stated without any supporting facts.
So you're saying it's like accusing someone without any evidence?
Exactly.
Oh.
Another common target are improper damage claims.
Okay.
Like maybe claiming attorney fees that aren't allowed or asking for punitive damages when they're not justified.
So it's about keeping things honest and preventing people from just throwing everything out there and seeing what sticks.
Right. But there are limits, of course.
Right.
Unlike demurrers, motions to strike can actually challenge the truthfulness of specific allegations. But you can only challenge them if they're demonstrably false on their face, meaning there's clear evidence that contradicts them.
So you can't just say, I don't believe you. You need proof.
You need proof, yeah.
Got it.
And remember, we're still early in the case, so we're focused on the information in the pleadings themselves.
Okay, that makes sense. But you said earlier that motions to strike are even more limited in limited civil cases?
Oh, yeah. In those cases, you can only use them to challenge certain types of damages.
So again, knowing the type of case is crucial.
Absolutely.
So we've covered demurrers, the broadside attack,
Right.
and motions to strike the surgical removal.
Right.
But what if we're a bit further along in the case? Are there any other legal moves we should be aware of?
There are. There's something called a motion for judgment on the pleadings.
Okay.
And this comes into play if, let's say, the initial complaint seemed okay at first.
Okay.
But then, as the case goes on, new facts come to light.
So it's kind of like a delayed reaction.
It's more like a delayed demurrer.
Okay.
It works similarly to a general demurrer, but it's used later in the case when things have changed.
So you're saying, hey, even if your pleading was fine at the start, it's messed up now.
Exactly.
Okay.
It's all about adapting to the new information that comes up.
Interesting.
And actually, the source material mentions something kind of interesting here. California Code of Civil Procedure, Section 438, it seems to restrict this motion to a specific time frame, but courts sometimes allow it later based on previous case law.
So there's some wiggle room?
There is.
It's not as black and white as it might seem.
Exactly. And this motion, it has the potential to save everyone time and money by avoiding a full trial.
Okay, so high reward, potentially.
Right.
But
Yeah.
what are the risks? What do you need to be careful of?
Well, you need a really, really strong argument.
Oh,
You
yeah.
have to convince the judge that the pleading is so fundamentally flawed that it can't be fixed no matter what.
So high stakes.
High stakes for sure.
Right, I've gone through a lot.
We have.
Demurrers, motions to strike, these late game motions for judgment on the pleadings.
Yeah, it's like we've unlocked a secret vault of legal tactics.
It is. But let's take a step back for a second
Okay.
and consider what all this means for our listener.
Right.
I mean, we've decoded all this legal jargon.
We have.
But why should anyone care about these procedures if they're not a lawyer?
Excellent question. We'll get into that right after this break.
Stay with us.
So, even without being a lawyer, just understanding these legal procedures, it can give you a whole new perspective on the legal system.
Oh, absolutely.
You start to see those inner workings, how those legal minds think, and how cases are won or lost sometimes before they even go to trial.
Yeah, it's like peeking behind the curtain, getting a glimpse of all the strategy involved.
Exactly. It's like having a decoder ring for this legal world, You can start to understand news stories about lawsuits. You can decipher those legal documents and maybe even navigate your own legal situations a little better.
Yeah, that makes sense. It's like knowing the rules of the game even if you're not playing yourself.
Right, exactly.
And what I'm seeing here, too, is that these procedures, they really emphasize the importance of having strong, clear pleadings.
Right. Oh, absolutely.
Whether you're writing them or responding to them, knowing how they might be attacked can help you create documents that are going to hold up under scrutiny.
Yeah, you got to think both offensively and defensively.
Right, exactly.
Yeah.
Knowing how to build a solid case, but also how to anticipate those challenges and how to counter them.
Exactly. And this applies even outside the courtroom, right?
Oh, really? Where else?
Well, think about it. Let's say you're in a business negotiation and you get a contract.
Okay.
Understanding these principles behind demurrers and motions to strike can help you spot weaknesses in the language, maybe some ambiguities.
Right.
That could give you more leverage during that negotiation.
So it's not just about courtroom drama. It's about having a sharper eye for legal language in any situation.
Absolutely. It's about understanding your rights and obligations.
And, thinking about it this way, it can also help you figure out how strong your own legal position is.
Oh, yeah, definitely.
Like if you're thinking about filing a lawsuit or maybe you're responding to one,
Right.
understanding those potential challenges can help you make better decisions.
Yeah, it's like doing a legal checkup, asking yourself, okay, if I was on the other side, how would I attack this?
Yeah, that's a great way to put it. It's like thinking like a legal professional, even if you're not one.
Exactly. And, it's also important to remember that the law isn't static.
Right, it's always changing.
Exactly. New laws, new precedents, the landscape shifts.
So it's not just about memorizing rules, you got to stay informed.
You do. This deep dive, it's like a snapshot of California pretrial procedure.
Okay.
But things can and do change. Which brings us to a really interesting question. Given all the limitations and risks of these formal procedures,
Right.
what other creative strategies might lawyers use to go after those weak pleadings without actually filing those motions?
Oh, that's a great question. It's like we've opened this Pandora's box of legal strategy.
Exactly.
We've seen the formal tools,
Right.
but now it's about imagining those more nuanced, creative ways they can be used.
Exactly. That's the exciting part of law. It's always challenging us to think outside the box. But before we go too far down that road, let's take a moment to just recap what we've learned so far.
Okay, good idea.
We started by talking about demurrers and motions to strike.
Right.
Their history, how they work, their pros and cons.
We covered a lot.
We did. And we saw how those procedures, they can be applied in everyday life, even for those who aren't lawyers.
Yeah, like analyzing contracts, navigating negotiations, even just understanding legal news better.
Exactly.
But as we've discussed, the world of law, it's full of surprises.
It is.
So with that in mind, let's explore those less formal strategies, those alternative ways lawyers might challenge a weak pleading.
All right. Well, skillful lawyers, they often use a combination of both formal and informal tactics. Think of it as a spectrum, right? On one end, you've got the motions, very structured, involving the court directly.
Okay.
But on the other end, you've got more subtle approaches, things
Yeah.
that rely on persuasion, negotiation, strategy.
So it's not always about throwing the rule book at the problem.
Not always, no. There's an art to it.
I like that.
For instance, even before filing anything formal, a lawyer might send a strongly worded letter to the other side.
Yeah.
pointing out the flaws in the pleading, maybe hinting at a demurrer or a motion to strike.
Oh, so a little legal saber rattling.
A little bit, yeah.
Yeah.
You show you're ready to fight, but you also give them a chance to reconsider.
Yeah, so it's strategic, right? Knowing when to apply pressure, when to negotiate, when to take it to court.
Absolutely. And another tactic is leveraging the meet and confer process.
Meet and confer. Can you explain what that is?
Sure. So in California, before filing any motions, the parties are usually required to meet and confer in good faith
Okay.
to try and resolve the issues.
So it's like a more collaborative approach, trying to find a solution together.
Exactly. And sometimes just talking it out can lead to a compromise,
Right.
especially when you're dealing with these pleading issues.
Okay.
So during that meeting, the lawyer challenging the pleading can explain the problems, propose solutions.
It sounds like a much more, friendly way to handle it.
Sometimes, yeah.
But what if they can't agree? Are there any other options besides going to court?
There are. Another tactic is to use the discovery process strategically.
Discovery, right. Remind me what that is again?
So discovery, that's the formal process of getting information from the other side in the lawsuit.
Okay.
And it can be really powerful. You can uncover evidence that might support your case or maybe weaken theirs.
So it's like conducting your own legal investigation.
You could say that, yeah.
Looking for clues that could change the direction of the case.
Exactly. Through things like depositions, interrogatories, requests for documents, lawyers can find information that might contradict what's in the pleading or maybe show holes in their arguments.
So it's not just about attacking the pleading directly. It's about gathering evidence that could hurt their whole case.
Precisely. And sometimes what you find during discovery can even lead to a motion for summary judgment down the line.
Wait, hold on. A motion for summary judgment?
Yes.
What's that?
That's a request to the court to just dismiss the case without going to trial.
Oh, wow.
You're basically arguing that there are no real disputes about the facts.
Okay.
And based on those undisputed facts, the law is clearly on your side.
So it's like a shortcut to winning if you can prove you've got a slam dunk case.
Exactly. And the information you find during discovery can be crucial to support that motion.
Wow. So all these early moves and the information you get during discovery, it can really have a big impact on the whole case.
Oh, absolutely.
It's like setting things up for a potential knockout punch later on.
That's a great way to put it. These procedural steps can really influence the outcome of a lawsuit.
Yeah, and knowing these tactics, it can definitely give you an advantage, even if you're not a lawyer.
For sure. I'm starting to see how all the pieces connect.
Me too. But are there any other creative strategies that lawyers might use? Those that don't involve those formal motions. What else is in their playbook?
Well, sometimes you see lawyers using public relations and media in a strategic way.
Wait, really? You're saying they might use public opinion to try to influence a case?
Yeah, in some cases, especially if it's a high-profile case or something the public is really interested in.
Okay.
If the allegations are weak or maybe really damaging, a lawyer might try to drum up some bad publicity for the plaintiff,
Interesting.
hoping to put pressure on them to just drop the case or settle on favorable terms.
So it's like a pressure tactic, but from outside the courtroom.
Exactly. But of course, you got to be ethical about it. It's not for every case.
Right.
But it can be a really powerful tool in certain situations.
That's fascinating. It shows how legal strategy goes beyond just the courtroom. Are there any other, maybe less conventional tactics that lawyers use?
Yeah. There's another approach that focuses on building a strong defense.
Okay.
Instead of just attacking the complaint.
Right.
So you might do some thorough investigations, gather evidence to refute what the plaintiff is claiming, come up with strong legal arguments.
So it's about being prepared, building a solid case that'll make their case fall apart.
Exactly. If you can show that their case is weak and you have a strong defense, you have more leverage when you're negotiating a settlement.
Right.
They might even just drop the case.
It's like you said before, that chess game, building a strong position to protect yourself.
Exactly. You got to think ahead.
Okay, so we've covered a lot.
Yeah.
Formal motions, subtle tactics, public relations, building a strong defense.
Lots of tools.
It seems like lawyers have a lot of options when it comes to challenging these pleadings.
They do. And the good ones know which tools to use and when.
Which really highlights why it's important to have a good lawyer on your side.
Oh, absolutely.
Someone who gets all this, who can come up with the right strategy.
For sure.
Someone who can guide you through the whole process.
Yeah, having experienced legal counsel can make all the difference.
It sounds like finding the right lawyer is key, no matter what side of the case you're on.
Definitely a key takeaway.
So we started by looking at these dense legal documents, and now we've uncovered all these legal strategies.
We have.
Both the formal procedures and the less conventional tactics.
It's been quite a journey.
It has. This deep dive into California civil litigation, I think it's given our listeners a whole new understanding of the legal process.
I hope so.
And, what I've learned is that those early stages of a lawsuit, it's really like a strategic chess match.
It is full of planning and calculated moves.
So the next time you hear about a lawsuit, or maybe you're facing a legal issue yourself,
Right.
remember what we've talked about today. Think strategically, understand the challenges, and most importantly, get good legal advice.
Yeah.
Couldn't have said it better myself. Well, I think that